Amendment 15, Lord Lucas.
So I beg to move Amendment 15 and speak at the same time to Amendment 31. My Lords, the Noble Lord the Minister knows what this is about. We've talked about it extensively before at committee stage. It seems to me now is the time to take all the good intentions expressed all the way around the House and reach some sort of conclusion. The purpose of this bill, or the purpose of this bit of the bill that we are just coming to, is to produce a sensible and civilised way whereby copyright owners can effectively enforce their copyright in a situation where the theft of copyright material has got seriously out of hand. And I think we have made a lot of progress in this bill, and with the amendments which the government are going to bring forward, to produce that effect, something which will start off by being educative, will be punitive only after very reasonable procedures have been gone through, and I very much hope will be effective. But unfortunately, there have sprung up what I would describe as abuses, but I suppose may not technically be abuses, but certainly as far as the citizens subject to them are concerned, are abuses of current practice. And the game works roughly like this. You find an owner of an obscure bit of copyright that is available on the internet. Preferably it's something pornographic and extremely nasty. You then employ a piece of software whose innards have never been exposed to the public or been tested in a court to produce allegations that a particular set of IP addresses had made that copyright material available for upload over the internet. You then take tens of thousands of these cases to the court, and using the Norwich Pharmacal order, obtain the details of the relevant subscribers from their internet service providers. You then write them a letter, which basically has three elements to it, really. One, it says, you have committed this transgression of copyright. Second, it says, if you force us to take you to court, we will pursue you for a very large sum of money. And thirdly, it says, but we offer you this opportunity to settle for a mere 500, 800, whatever it is, pounds, and we'll forget all about the perils of court and the vast sums which you might otherwise be entitled to, because basically we're very good people, and all we're seeking to do is protect our copyright. My Lords, the reason this particular scam works is because of the impossibility of producing proof against this allegation. How can you prove that you did not do this thing without going through an immense... I mean, you have an internet connection. They say it was done over the internet connection. It's no good producing your computer because perhaps you committed the offence using a different computer. It's no good saying you're a 97-year-old widow and you hardly know how to use a telephone, let alone the internet, because nonetheless you have an internet connection and they say it was abused. You can't... It is extremely difficult to produce evidence to gainsay this. All you can do is deny it. And one of the things they say in the letter is, don't bother to deny this without producing evidence that you didn't do it. And so the result of this is that a very large number of people pay up as a result either of the first letter or of the letters that follow. And so far as I can discover, despite the tens of thousands of orders that have been granted, the solicitors involved have never taken a case, a seriously contested case to court, because getting money out of people on the basis of the compromise offer is actually what is lucrative. Now, my Lords, there may not be truth at the root of this, but this is a route for obtaining redress for copyright abuse, which has been neglected, and with good reason, by the reputable end of the copyright industry, which produces a great deal of distress and indignation among many thousands of our citizens, and which ought not to be allowed to continue. Now we have produced a better and proper route, now we are producing a better and proper route for redress for copyright owners, particularly where we are looking at volume cases where we are looking at large volumes of infringement, this is exactly what this bill is aimed at dealing with. So my amendments 15 and 31 look at a couple of possible ways of dealing with this. Either we act on the internet service provider and we give them a defence against revealing their subscribers' details to say that it must, either they or a court must have been satisfied that the process being used is a fair and accurate one, or we give the court power to say that no, here's this act which provides a proper remedy for copyright owners who are suffering from the sort of abuse which is alleged in these letters. Let them use that route because that is fairer to consumers and a fairer basis to be operating on, and that is what Parliament have decided, and lay aside and lay off the orders which are the techniques which are being used to extract money at present. I mean, mostly to date, there has been one firm involved. We now have a second firm getting involved. Doubtless, the news of how lucrative this is has spread, and we will, if we don't do something about it, have more firms creeping up into this business. There is plenty of copyright in unpleasant material out there. There are plenty of opportunities for these firms to make money. It really is high time that we did something effective to put a stop to it. I don't mind which of these amendments the government chooses. I suspect if I was forced to choose between them, I would choose the Liberal Democrat one. It may not be perfectly drafted, but at least if we get it into the bill now, the government will have an opportunity to redraft it for third reading. But this must not be allowed to continue. I beg to move. It does, as the Noble Lord I think has pointed out by making a reference to rogue wheel clampers, seem to take a very long time and the suffering of many tens of thousands of people before a government will move to deal with an abuse which has some justification in fundamental law. I mean, rogue wheel clampers are merely enforcing their rights of private property. And one could bailiffs, I suppose, are doing an excellent job in retrieving lots of money for the public purse and for creditors. And here we have another case where many tens of thousands of people are subject to something which is not as we would wish it to be in a proper and perfect world. I appreciate what the Noble Lord says about there being deeper questions here. I understand that my own front bench share those qualms. What I would really like, other than an expression of sympathy, is an expression of a determination to deal with this question if it continues or it gets any worse. That would be immensely helpful to hear from the government, to know that this is something which will not, is not a permanent disfigurement on the face of copyright law and practice. But if the SRA can't deal with it, we will find some other way of dealing with it ourselves. To know that that was the position of the government would be a great comfort.
If I can be of help, I mean, we will continue to pursue with this problem with the Ministry of Justice and with the SRA. I mean, I give that assurance because we certainly share the concerns that this is a problem that doesn't look like it's going to go away, even should this bill be introduced. So that commitment is there, and you know, I give that as if that helps.
That is appreciated, yes, to know the direction. I'm sure my noble friend on the front bench shares that sentiment, though I won't press him outside the rules of a report to say so. With grateful thanks for that, I beg leave to withdraw the amendment.